Welcome to American Common Sense, a fun look at the state of American politics, inspired by Thomas Paine's Common Sense from 1776, hosted by James Humphreys. Welcome back to another episode. We're excited to have you here with us. I want to go over a couple of things that are very different and talk some stuff that's personal today about what I believe so you can understand where I'm coming from with the Constitution as a rule. Remember, in one of our previous episodes, we talked about how the Constitution was a document that ensured, for the first time ever in history that we know of, recorded history, and certainly one of the only documents even in use today, where the government derives its power from the people. So the people tell the government what it can and cannot do, not the government telling the people what rights they do or do not have. And that's a very different concept. Because of that concept, which is very clearly laid out by our founders in multiple documents, all of their writings and so forth, we look at the Constitution and there's a couple of things that people think about. Is the Constitution a limiting document or is it an enabling document? Does it give the government lots of power or does it limit the government's power on the people themselves? And considering the thought processes of the day and the fact that we already know that the consent of the governed is what creates power for the government, it's very easy to assume that all of our founders wanted the Constitution to be a limiting document. So I treat the Constitution as a limiting document. A lot of examples of that are clear in the Constitution itself. I'm going to pull out my handy dandy little pocket Constitution, read directly from it for you today on these things. In Article 1 of the Constitution, that's the establishment of all the powers for the legislative branch, for Congress, the House and the Senate. And it lists everything that they are meant to do. And in Section 2, it's the executive powers, and in Section 3, it's the judicial powers. And then there are other things about how the states interact with each other that exist in like Article 4 and Article 5 and so forth. But one of the things you'll notice was the Constitution immediately, as you know, had the Bill of Rights, the first 10 amendments, because there were a number of states that were concerned that the Constitution didn't enumerate some very specific powers. And so one of the most famous that is used all the time by conservatives, for example, in the United States, is Amendment number 10. And the 10th Amendment says, I'll read it very specifically for you. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So the 10th Amendment lays out a fundamental tenet of government that's really important. And I'll read that again. It says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states. In other words, the Supremacy Clause, for example, saying that the states, when they agree to join the Union, are subservient to the U.S. federal Constitution. So powers not given directly to Congress, powers not given directly to the president, and powers not given directly to the courts are reserved to the states themselves or to the people. Moreover, the 9th Amendment, which is an amendment that most people ignore, but it is probably the most important amendment that is ignored by the courts and by historians and so-called constitutional scholars, is probably the most important amendment in the document to me. The 9th Amendment says, the enumeration in the Constitution of certain rights shall not, not may not cannot, shall not be construed to deny or disparage others retained by the people. In other words, we all have all of the rights. Each of us as individuals have all the rights. Our rights end where we infringe on someone else's rights. That's a very clear doctrine. My right to punch someone in the nose ends where their nose starts. Just like my right, I can use free speech to yell and scream at someone all I want, but there are limitations, like I can't yell fire in a theater and cause a trampling effect, an emergency that causes damage to other people because I'm infringing on their rights at that point in time. So while there are minor limitations, as a rule, the 9th Amendment says all rights belong to all people. The 10th Amendment says only the things in the Constitution belong to the federal government, and if it's not prohibited to the states, it belongs to the states or the people. So I like to think of the way we look at government, the way the Constitution lays out the government, as a triangle, with the people as the foundation, we the people at the bottom, local and state government in the middle, because all local government is subservient to the state, just like states are subservient to the federal government. And then the federal government is meant to be the smallest government at the top of the pyramid. So there'll be a little graphic. I hope that works for you. You can kind of see what we're looking for here. And that is further evidence of the limiting power of the Constitution, not the enabling power. I'll give you one more example, and then we're going to talk for a second about something that's important in the judiciary, and that's what I want to talk about today and why this matters for what I'm talking about with you today. That is Article 4 of the Constitution. Article 4 says, "Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And Congress, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof." Now, if you just read that by itself, what that means is very simple. It means my driver's license from California or Utah or Texas must be recognized in Vermont or Washington or Florida, because that is a procedure, a judicial act, record, or procedure that's given to me as a privilege of the state that I reside in or the state you reside in. And the other states have to recognize that in order for us to be part of the fabric of the United States. So, insurance and driver's licenses and marriage licenses and so forth are recognized across state boundaries by Article 4, Section 1. But because it gives Congress this is very interesting to me. It says Congress may, by general laws, prescribe the manner in which these acts, records, or procedures shall be proved, means Congress has power to decide how that's going to happen. The consequence of that is that sentence all by itself kind of makes it sound like Congress has unlimited power to regulate how the various acts, records, and procedures are affected across the country, that they have the right to unlimited access to how that would work. But if the Constitution's a limiting document, that seems rather contradictory. So you just have to look at the very first sentence of Section 2. Section 2 says, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states." Now, that creates a limit on the full faith and credit clause to Congress. Congress can, by general law, prescribe how those things are going to be handled. However, if I'm a citizen of state A and I want to go to state B, all privileges and immunities that I am granted in state A must be recognized by state B. In fact, the word it uses is shall. The citizens of each state shall, not may, not could, not subject to Congress, shall be entitled, okay? To all, not some, not a few, not the ones they think we should have, all shall be entitled to all privileges and immunities, which means, for example, I use the marriage one. That's the biggest and easiest one to work with because that was a recent controversial issue in the last 15 years here in the United States. If I have a marriage license from California and I move to Texas, which there are a lot of people doing that right now, and I want to get divorced, but Texas doesn't like my particular marriage, I still have to have access to the court system in Texas as a resident of Texas at that point in time in order to access the courts to be able to process a divorce or child custody or alimony, those kinds of things to be handled. If I have a California marriage license and that license isn't recognized in Texas, the consequence of that is that I wouldn't be able to effect a divorce or manage those things in case of a dissolution in that relationship. That's why Congress isn't allowed to tell Texas that they have a right to ignore a marriage license from California. The same thing is true on the conservative side if you talk about something like concealed carry permits. The Supreme Court has made the mistake. They are wrong in this, and the Constitution is very clear, so I hope it will be challenged again. They may not say that a concealed carry permit from Utah cannot be recognized in Illinois. Because if I have a concealed carry permit and I live in Utah and I happen to be traveling through Illinois and I have that gun in my car and I get pulled over by accident, as a result of speeding or a tail light or something in Illinois, and I tell the officer that I have a gun, even though it might be illegal for me to have a concealed carry permit in Illinois, they are required to recognize my concealed carry permit from Utah. Shall be entitled to all privileges and immunities. The only way to strip me of the concealed carry permit would be to have an Illinois court strip me as a Utah resident of that concealed carry permit, which means I have to access the court system again, which means that even though it was administratively given to me by a county clerk or something in Utah, the reality is I have to access the court system in order to have that permit removed from me, and therefore that is a judicial act, and that act is not subject to congressional review because Illinois is required to recognize it. So I've used two issues, the right and the left, to try and show you what that looks like so you can understand where I'm coming from when I talk about the Constitution being a limiting document. So what we want to do is, as we read this, when people say things like the president last week, for example, said that this particular act to deport certain people, the Alien Enemies Act, is not subject to judicial review. Well, the reality is every single thing and every single person is subject to judicial review in some form or another. Almost all of them on the U.S. judiciary are related to state or branch of government conflicts. The only thing that doesn't go to the federal judiciary would be let's say I got a speeding ticket in Texas. Well, the offense occurred in Texas. It happens in the Texas jurisdiction. If I fight the ticket, I could fight it all the way to the Texas Supreme Court if I wanted to, but I could never take that to the federal court because a speeding ticket in Texas that only affects Texas doesn't cross state lines and is therefore not subject to federal law. I hope this has been helpful. I hope this helps you understand where I'm coming from as I explain a few things that will work in the future. The reason I mention that is I want to talk about the justice system in general and how our government has gotten away from having justice for all in the sense that it applies equally to everyone. And the example I want to give you today to show what a difference that makes is the classified issues that's currently happening right now with classified information being handled on a secure but unapproved government chat site between the Secretary of Defense, National Security Advisor, the Vice President, and a few others that accidentally somehow included the editor-in-chief of The Atlantic magazine who had no security clearance and is clearly a journalist. We don't know what's going to happen with that. We don't know if anyone will be punished or if anyone will be fired as a result of these things. But we know this. We know that in 2022, a gentleman by the name of Jack Teixeira, I always pronounce that incorrectly, I apologize for that. He's an airman, in the fall of 2022 was caught on a Discord server sharing classified information. Between then and November of 2024, he was caught, investigated, charged, pled, found guilty, sentenced, and is already in jail with a $50,000 fine and 15 years in prison. Already in jail before the November of 2024 election. Whereas our current President Trump had a warrant served on his property there in Mar-a-Lago on August the 8th of 2022, and justice moved so slowly for him that because of the election in November of 24, they were forced to drop the case, and despite the fact that both he and this Mr. Teixeira fellow were charged with the exact same crime of mishandling classified information with plenty of proof, the current president suffered no consequences. He may have suffered consequences, but the court system moved significantly slower for someone that had more power or more money. So there was clearly two tiers of justice in that situation. Those on the right in the United States will also argue, and they are correct, that President Trump has been subject to significantly more investigation than anyone else in his shoes from his contemporaries. Meaning that other members of the political class or very wealthy class are not charged as often for these types of crimes, or investigated far less, and are generally only charged when a guilty verdict is all but guaranteed in the case. The consequence of that is it ends up showing that there's kind of three tiers of justice in the way that the executive branch's Justice Department applies federal law using the judiciary branch for violations of congressional laws passed by the legislative branch. Those who don't have the means or the fame cannot get justice handled. Well, let's put it this way. Justice moves much more quickly for them, and they end up in prison far more often than those who have power or money. We already know this is the truth. But even inside that group, there are times when it appears that the Justice Department specifically targets individuals whom they may not like. And it varies from administration to administration. During the Biden administration, a lot of people complained the Justice Department was unfairly going after President Trump. And clearly, as a result of a speech that President Trump gave at the Justice Department in front of all the prosecutors, where he named names of all of his political enemies, the Justice Department under President Trump is going after his liberal political enemies. We need to find a way to ensure that justice in the United States is blind once again and follows what the founders expected, and that using the Constitution, we not only find that the justice is going to be equally applied, but more importantly, that we recognize that far too many laws that are currently written violate the rights of us as citizens. As the Ninth Amendment says, we have all the rights. The government has less rights depending on the form of government, where it's at, or the level of government, I should say. The states have more power than the federal government is supposed to have over our lives individually, and the federal government is supposed to have less. And I expect that will be the case moving forward. And I hope that each of us would stand up and say, no, these are my rights, and I expect them to be enforced. So I hope that was really helpful for everyone, and I'm grateful for all of your time. I hope that made some common sense. And until the next time, continue to read this wonderful little pocket constitution and ask the questions that need to be asked and ensure that your rights are being protected.